Good afternoon, ladies and gentlemen. My name is Ronaldo Hilton, the chairperson designee of the New York City Loft Board. I want to welcome you to our February 15, 2018 public meeting. Section 282 of the New York State Multi-Dwelling Law establishes the New York City Loft Board. The board is charged with overseeing the timely conversion of intra-multi-dwellings from commercial and manufacturing spaces to safe, rent-stabilized residences that comply with the minimum standards of safety and fire protection stated in Article 7B of the New York State Multi-Dwelling Law. To achieve this goal, the board adjudicates and mediates disputes between owners and tenants, tracks the progress of each building undergoing legalization, and prosecutes parties who violate the Loft Law and the Loft Board rules. So we'll first turn to a vote of the minutes from our January 18th public meeting. Board members, are there any corrections or comments to these minutes? There's no comments or corrections, so is there a motion then to accept these minutes? Mr. Hernandez. Second? Mr. Shack. Mr. Rivera.
Mr. Cover.
Yes.
Mr. Barrett.
Yes.
Mr. Rose.
Yes.
Mr. Hernandez.
Yes.
Mr. Delaney.
Yes.
Mr. Shackman.
Yes.
Chairperson Hudson.
Yes.
7 in favor.
Thank you. Ms. Heather Boston, now the Loft Board Executive Director, would like to give her report.
So I have a few things to report on for February. The board vacancies, the mayor's office of appointment is still working hard to fill the vacancies. We've been told that candidates have been, some at least have been identified and are going through a process. The board staff and DOB's Office of Technical Affairs have begun discussing a training plan for a designated group of plan examiners who will look at loft buildings. As you know, these buildings can be very complex. There are often conflicting opinions, and we're trying to streamline that process. We are also assisting technical affairs. They will be doing all the work, obviously, to develop a set of loft law buildings project guidelines. In the past, buildings would publish notices and TPPNs, technical policy and procedure notices. So this is, again, an idea of getting everybody on board. So the technical affairs people will be drafting a series of guidelines, which will then go out to design professionals in the loft community who will have a chance to review and comment. And the idea is for it to be a back and forth with the design professionals for both tenants and owners, obviously. In terms of our unofficial revenue,
Could you just elaborate on what kind of issues are under discussion?
so we received a lot of information from the architects on both sides. We received a whole series of stuff from tenants, one of the tenant architects, and a whole series of things from an owner's architect. So it was things like mezzanines, alcoves, depths of units. I mean, there's a whole bunch of things. So the idea is to go through, figure out what the law is, which, you know, the plan examiners know, but to give guidance to this designated set of plan examiners with input from the industry. Project guidelines are out there for other business that DOB does, so it's not just unique to loft buildings. They're not developing just for loft buildings. There are several sets of project guidelines already on the building department's website.
So does this anticipate there being a designated group of plans examiners that would be kind of the first responders
Yes.
to loft issues?
Yes.
Okay. And is there any kind of timeline for how long this process is going to take?
It is not a fixed timeline, but we're working very hard to get it done within 3 months.
Thank you.
So unofficial revenue for January was $68,672. On the enforcement side, our staff has been busy. We sent out 76 NOVs to owners who failed to file monthly reports for December. looking at the statistics, at least 31 of those were owners who were repeat violators. So we are discussing next steps as to how to deal with the recidivists. And if anybody has suggestions on that, they are all welcome. Out of those 76, 20 of them were cured as of yesterday, which is great because that means they're filing the reports, which is what we want. 2 were administratively dismissed because the buildings are not yet required to submit reports, and the deadline for the rest of the cures is February 26th. We also issued 3 violations for failing to timely file sales of rights forms, so it took us a little while to work through all the kinks in the computer system, but we finally ironed them all out, so we will be issuing violations for failure to timely file sales of rights, and we've already issued 3. And in addition, our HPD inspector has started his neighborhood sweeps to see whether or not signs are posted in the lobbies of the buildings. So far, he's issued 3 violations, but he actually found quite a number of buildings that had the signs posted. So I think it's great that we redesigned the sign and sent it out to the building owners. So we're hoping that that will continue.
And we're trying to do something in terms of making that suppose, make the signs better and more, I guess,
Well, I think.
in terms of display.
Well, I think in terms of the going forward, when we do rulemaking, right now the rule is kind of vague. It says, you need a sign that has this information that's approved, and you can find it on the Loft Board's website. But it doesn't say it has to be framed or whatever. It just says it has to be up there in the lobby. So yes, I think we can, in future rulemaking, put in more requirements as to how it should be displayed, behind glass or plexiglass or something like that.
My landlord just put up a sign that's got this together.
Your landlord did?
Yeah.
Well, it should be an 8.5 by, the sign itself is an 8.5 by 11 sign. I think I held it up at one of the meetings last
Yeah, for real. Come over anytime.
Okay.
Would you be kind enough to send me a PDF of the
sign.
hard copy you distributed a couple months ago?
Sure.
Yeah. I'd like to send that around.
There's similar, in the agencies like the building department and fire department, we have similar posting requirements. For example, public assembly sign has to be posted certain dimensions, I don't know, behind glass, right? And I think we should definitely look into improving those signs. As you said, maybe
In terms of registrations, we still have 19 buildings that failed to register. We've sent out orders imposing fines. And in terms of litigation, we had 2 cases come in this month. Well, one came in at the end of January. We were served with a lawsuit requesting the tolling of plaintiff's code compliance deadline to obtain a permit. Plaintiff contended that it could not timely obtain the permit because the law courts failed to schedule a narrative statement conference, and DOB failed to issue an objection sheet. That is questionable in our opinion. We think they were a little dilatory on their side. But anyway, so that's one case. And the other case is the roommates at 79 Lorimer Street have commenced an Article 78 proceeding asking the court to overturn the board's decision denying them protected occupancy status. So it'll be interesting to see how the court rules on that. And that's it. Anybody has questions?
I have a couple from last month's meeting. I had asked if you could take a look to see if the current backlog of cases, how that compares with the backlog over the prior couple of years, to see if we're making headway or not. And I don't know if you've had a chance to do that. I'm sure.
I did compare this year and last year, or last year and the year before, which I had easy statistics available for because I had done the report, and it was about the same. I think we were 2 cases above where we were the year before.
Okay.
I didn't go back further than that, though.
And one of the things I missed in your report last month, but kind of jumped out at me in the minutes, is the 81 narrative statement certifications, including 6 partial certifications for work that involves heat and public safety issues. Could you just describe that a little bit?
So usually that would be where either we haven't issued a certification yet, or it would be an amended certification, but it's emergency work. So somebody doesn't have heat, and the landlord needs to do emergency work, and they come in and ask us for a certification for that. Or the much more common one is the sidewalk sheds. So the landlord does a local law 11 inspection, the building is safe with a remediation plan, or unsafe, but they need to put up protection, so usually it's sidewalk sheds. So we'll issue, and they can't pull a permit for the sidewalk shed because of the loft board hold in biz, so they'll come to us and ask us to lift the hold to put up the sidewalk shed, and we'll give them a certification, which they can then use to get the permit.
Got it. And then I had asked about heat complaints, and you had mentioned that most landlords are taking care of the issue by giving temporary heat, and I just asked if you could try to quantify that.
Yeah, I dropped the ball on that one, I'm sorry.
Okay.
That's still heating season.
Anything else on the report?
I'd like to talk about the DOB data, but we can do that after the cases if you'd like, or now as you prefer.
Go ahead.
In general, would like to try to get a better sense of coordination between DOB's general processing of permits, TCOs and COs, and how that is different for properties in the Loft program. And I also you had mentioned the question about what to do about recidivists, particularly the owners who repeatedly fail to register, pay fees, et cetera. And one of my questions is whether it would be possible to coordinate that with how DOB processes permits or other work for those owners. In other words, if they still owe us money, should that have an impact on other services that DOB is providing?
So for the landlords that don't register, I think the bulk of them aren't doing anything at DOB. It sort of goes along together, that they're not registering and they're not legalizing. For the landlords, although that's not always the case. In terms of pulling permits really for anything, now when did the whole start, do you remember? Before me?
Yeah, I think it was in 2009.
I think it's after that.
No, it was definitely in place when the law was amended already. I want to say 2008, 2009.
So it used to be that DOB really had no way of knowing what was going on, but now we put a hold on all of the buildings that are under our jurisdiction, and the owner can't pull a permit basically for anything without Loft board approval, so they have to come to us, we have to take a look at what they're doing, see how that impacts, even if it's work in non-IMD space, see whether or not there's an impact on the IMD spaces, and issue them a certificate or a loano, and then they can go and pull the permits. And that, I think, has done a lot to address this whole idea of we don't know what's going on in the buildings. For the C of Os, I mean, there are, usually they will come to us and say, you know, this building has applied for a C of O, and, you know, does the Loft board have any outstanding issues? And we'll take a look, do we owe us any money, is there anything going on? And that's pretty much it. The TCOs, other than that, they file them with us to show that they're in compliance with 7B, because a TCO, if they get a TCO, they're in compliance with 7B because they can't get it without it. Other than that, I don't know that we necessarily track them.
So they could they get a TCO without having paid all their outstanding fees?
I think so. I think that's possible.
What fees? The Loft board?
Fees that they owe the Loft?
We do the TCO.
You do a TCO review, also a CO review?
Yes.
Okay, yes, sorry. No, they can't.
Okay.
So
I
basically,
know we did it for COs and
So-
TCOs too.
so that's my question then, so that means, do we give like a loan for a CLO? Is that what you mean?
No,
When you
it's
say you
not
do a
a
review?
no,
It's not a-
it's a form
So-
that is signed by Glenn. And what they do is.
Releasing basically Loft Board's objections from the CLO.
Yeah,
issues.
what we check is to make sure whether the IMD spaces are legalized, and if not, are they lessee?
Are you checking to see what some of the issues, the chapter?
Yes,
Yeah.
yes, we also
Right.
check to see if
Make
they
sure
owe
that
money.
they don't
Right,
owe us
Yes,
money.
That
I mean, not that that's the
they-
most important thing.
Right.
yeah. no.
But among
But
other
the primary
things.
is to figure out.
First we
what
look at the number of
IMDs
IMDs,
is.
yeah.
Right.
Yeah.
And this sort of process is triggered by at what juncture for the property and the loft? Is it as soon as tenants submit requests?
The owner submits a request for a TCO.
For the CO.
No, I'm sorry, I'm jumping back to at the very beginning of the process where in effect, the loft board tells DOB, this property is now in our jurisdiction, is going through our process. What is the triggering event that prompts that?
Well, so let's assume that there was a coverage application that the board has granted and the owner has registered, or in the case, sometimes the owners don't register and we assign an IMD number, but when the IMD number is assigned to the building, that's when we put the hold in biz and we enter it into the DOB system to say, this is a loft, if there's a flag, loft law, yes, no, so it becomes loft law, yes, with the IMD number next to it. Now, before that, we can enter in application pending, but we can't do a hold on an application pending because we don't have jurisdiction yet. So theoretically, to follow that through,
Yes, please.
right, you could have an application pending status, and an owner could file to do work in the building that could impinge on
The tenants.
the prospective IMD spaces, and that would be problematic. That would be problematic.
And that's exactly what I'm trying to figure out.
But I don't know what we can do about it because we don't have jurisdiction. We don't have jurisdiction when the application's filed. If the owner registers, then that's not a problem. But if it's just a coverage application, the board hasn't made a determination yet.
And a pending application is not noted in the business.
It is.
It is.
And I actually, after the last meeting, went through every building that had an application pending to make sure that they had it, and there were some that didn't, and we flagged it, and they had it. But there isn't the hold. So somebody on the DOB side will see, hey, something's happening with Loft in this building, but the physical hold isn't there. That hard stop is not there. And sometimes they'll call us and say, what's going on with the building? The DOB people will call, but not always.
All right, so that might be a potential. I mean, I'm not suggesting there's necessarily anything that can be done. I'm just saying, your hypothetical sounds like an entirely feasible risk. Is there any other way to, well, all right, you said that the recidivists are, the people who don't pay our fees and don't register are generally not doing stuff anyway.
Right.
And I guess my only other question, is it possible that, just in case there's a possibility that an owner who is unresponsive about a given building may be doing activity with other buildings, is there any way to then obtain any leverage?
Other, what buildings,
Non-law. And by that, in terms of the ideas, if they owe us money for law for one building, and they're getting approvals from DOT for another building.
I don't know.
Seems un-American. Seems communist.
Well, almost like, you know,
I can only say that my work in the federal government, that this is a responsibility, is that, you know, that people try to make sure that the system isn't gamed, that people don't.
Can I
you
just
know.
say, it makes a difference as to what is owed. What kind of money is owed to the city, and who is it that owes the money? You know, it's very complicated. So it's not fines and penalties that are assessed by the courts are not factored into permitting, you know, whether or not the DOB will grant a permit to an owner. Right, at permitting.
Okay, no, I just.
But they
now
don't
that-
have to pay their permit fees and so on. So it's different types of things, and we just don't have the leverage, or we don't have the law on our side to withhold certain things for penalties and fines.
Even though, and I understand that the law board's role, relationship to DOB is complicated. But
Right, so certainly, you know, I mean, what you're saying there about comparing the Loft board world and other, you know, the other, and what's outside the Loft board, I don't think is something we should try to coordinate. And, you know, I don't know if the agency, it is way above my pay grade, put it that way.
I think also there's an issue about, you know, who's an owner, because most buildings, I think, are corporate ownership, so, you know, even if you have the same principles in a building that isn't under the Loft board's jurisdiction and a building that is under the board's jurisdiction, you wouldn't necessarily know that, because you're looking at a corporate owner. So I don't know how you would have to pierce the corporate veil in order to get there. So that's another level of complexity.
And fines
Okay.
owns, just so you, also to be clear,
finds
fines,
that the federal government's systems are more sophisticated than cities, but okay.
I would hope so.
fines owed on a building are not necessarily the owners either. Because they are against, you know, licensed, you know, people who do work on the building. You know, so it's hard, you know, most of those fines are so it's not against, you know, Nina bill against the building.
All right, I was just focused on the monies that clearly are repeatedly and built compoundingly outstanding. But
I'm sorry.
that's all right.
Well, we talked about that
Point out that it was a law board staff member who, perhaps 12 or 15 years ago, a then staff member, who came up with the letter of no objection idea, which has proven to be extremely effective. And while Mr. Schachter's ideas don't show an immediate way to pathway, the notion that there might be some way to deal with some of the more egregious recidivists or non-performers might be worthy of some more discussion by the board and some thought.
I'm all in favor of that.
You know, I've advocated occasionally that perhaps a specific performance case or two would be a helpful comment.
Motivated.
Yeah, motivating.
We'd have to get the law department on board with that, but I can't disagree with that.
That's it, Mr. Chairman.
Yes.
Are there any other, I think,
I just had a question about that. My understanding is that any of these property-related fines are never enforced against an individual, but just remain liens on the realty. Is that the typical case?
no, others not. Most of these fines are in persona, meaning it's against the person to whom the violation was issued to, so that it may or may not be lienable against the property itself.
May not be liable against the
Property.
property.
I think it depends on, it depends on who issues it, where it's heard. You know, there's lots of permutations. So an ECB violation is in personam, it's not in rem. There are some violations that are in rem and not in personam. So
It varies.
it varies, yeah.
So when we issue a fine for failure to fulfill obligations, which is that? Is that realty or is that?
We treat it as against realty, because even if the owner switched, then we would still say that that's running with the building, so that the new owner would still be responsible for those fines.
But those are not, are those liens perfected?
No,
Some of these recidivists, how, months, years? Do we have a record on
there's
how
a,
long this can go on?
well, there's two different types of recidivists that we're talking about. Those are the ones, there's the non-register people, the people that didn't register, and there's a handful of them where it's multiple years. And then there's the monthly reports, and as I said, we identified 31 of those. So the monthly reports, I mean, we could do something about, you know, we typically issue those violations twice a year. Maybe for those, we want to issue them more often to see what happens. We could change the penalty structure to, you know, we can't do it without a rule change, but we could theoretically change the penalty structure to have a higher penalty if you're a recidivist. So, you know, there are things to do. Right now, I think the only avenue for us, unless anybody has another suggestion without changing the penalty schedule, is to issue those violations more often to the people that aren't filing the monthly reports.
Would there be a way of, I mean, how, is there a vehicle for perfecting the lien, putting those liens on the property?
I assume that, you know, we could refer it out to collection and the law department could have their outside collectors work on it. But as I said at another meeting, I don't know exactly when.
You said that there's a
problem is
substantial
that-
discount.
Yeah, so.
We can't just ask the law department to perfect the lien?
I guess we can. It's a question of where they're gonna put their resources. We could certainly ask them. And for some of them that owe us, you know, 6 figures, and there's only really maybe 1 or 2 of those, they would probably do that themselves in-house and not send it out. That's just from my experience at ECB. That's typically what they do. But anything less than that, they're gonna send out to an outside collector who could collect the lien, but they don't get paid if they don't get money. So it's the collectors want to collect on those liens. So,
Let me just ask another question. Is there one collective agency that does this?
the law department has, and I forget what it's called, the name of the department, the division within law department that brings actions.
Oh, it's in the city
Affirmative
itself?
litigation.
It's in the city itself.
The law department has an affirmative litigation division. Part of that division is collections.
Okay.
So there are attorneys that work for the law department that do collections, but they also have a contract with outside collection law firms.
They do.
And, you know, depending on the size of the debt, they will quite often refer the smaller debt out to the collection law firms, who will then settle the cases for a very small amount of money. And I don't know that that really serves us well.
That's, all right, that's what I assumed.
Yeah.
Okay.
Thank you. Thank you, Ms. Bolton. We now turn to the 2 cases that are on the, we now turn to vote on this month's cases. We start with appeals and reconsideration calendar. There are 2 cases on that calendar. The first is an appeal. That's Melinda Burns and Stephen Grant, 329 Greenwich Street in Manhattan. The docket number is 800093. Ms. Cruz, you will present this case.
The facts surrounding this appeal involve an order issued by the board in June of 2013. In order number 4157, the Loft Board denied claims of unreasonable interference based on the plan to legalize the fourth floor as 2 units, and denied as untimely the claim to exclusive use of the vestibule space immediately in front of the entrance door of Unit 4F. The Loft Board mailed the order on October 7th of 2013. The tenant of Unit 4F did not seek reconsideration of the order pursuant to the Loft Board rules. Instead, in October of 2013, he filed an Article 78 petition challenging only the finding that the fourth floor consisted of 2 units. On September 18th of 2014, the tenants of Unit 4F filed for reconsideration concerning the vestibule space. On October 16th of 2017, the Loft Board staff issued administrative determination rejecting the application because it was untimely. On December 1st of 2017, the tenants of Unit 4F filed this appeal seeking review of the staff's determination. Section 107 of the Loft Board rules requires that an aggrieved party request reconsideration of the Loft Board order within 30 days of the mailing of the order. Here, the staff mailed the order on October 7th of 2013, and the tenant sought review in September of 2017, nearly 4 years later. In the appeal, the tenants failed to address how the reconsideration was incorrect. The tenants only argued the merits of their claims. The staff recommends that the board deny the appeal.
Thank you, Mr. Cruz. Are there any questions or comments about this case? No? Is there a motion to accept this case? Mr. Carver, second. Mr. Schachter. Ms. Rivera, please.
Mr. Carver?
Yes.
Mr. Barrett?
Yes.
Mr. Rouge?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
Yes.
Mr. Schachter?
Yes.
Chairperson Hudson?
Yes.
7 in favor.
Thank you, Mr. Rivera. The second is a reconsideration case. It is 138 Emmett Properties LLC at 134 through 146 Bowery in Manhattan. The docket number is R0354, and Ms. Level was represented.
Board members, on April 12, 2017, owner filed a reconsideration application seeking review of Loft Board Order number 4640, which imposed the fine for owner's failure to renew its annual registration. On October 19, 2017, the Loft Board staff issued a notice for owner's failure to renew its registration for the 2017 and 2018 fiscal years. On January 10, 2018, owner filed a letter withdrawing its reconsideration application after paying all of the outstanding fines and fees. The Loft Board staff recommends that the Loft Board accept owner's withdrawal.
Thank you, Mr. LaBelle. Does anyone have any questions or comments on this case? So do we have a motion to accept this case? Mr. Schachter. Mr. Hernandez was second. Mr. Rivera, could you please
Mr.
poll the
Carver?
board?
Yes.
Mr. Barrett?
Yes.
Mr. Rouge?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
Yes.
Mr. Schachter?
Yes.
Chairperson Hudson?
Yes.
7 in favor.
Thank you, Mr. Rivera. There are 2 cases on the summer calendar today. They are voted on as a group. The cases are Julia Newman and Elkin Hart, 105 Broadway in Brooklyn, docket number TR1324. And Carl Frederick and 1 Bay, and 105 Broadway in Brooklyn, TR1336. Does anyone have any comments on this case? Or questions?
Yes, on the 3, I think we have some minor language change.
This is the Julia Newman case? Yes?
Yeah.
Okay.
So the last line is going to read, upon such registration, the coverage and protected occupancy claims of Elkin Pout are deemed withdrawn.
Thanks.
Thank you. With that correction, is there any motion then to accept this case? Mr. Carver? Mr. Hernandez? Mr. Rivera, could you please poll the board?
Mr. Carver?
Yes.
Mr. Barrett?
Yes.
Mr. Rouge?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
Yes.
Mr. Schachter?
Yes.
Chairperson Hudson?
Yes.
7 in favor.
Thank you, Mr. Rivera. There are 5 cases on the master calendar, including 2 removal cases. The first case is Brianne Catherine Blessing at 870 Broadway in Manhattan. Docket number P00014 and TA0209. Mr. Clark, please present this case.
Board members, tenant occupant of the fourth floor unit filed an application seeking protected occupant status in a rent dispute application. In its answer, owner argued the tenant is not entitled to the protected occupant status due to the sale of rights that took place in 1995 pursuant to MDL Section 286-12. Tenant argued the 1995 sale was not valid for essentially 3 reasons. First, tenant argued prior occupant was not entitled to protection at the time of the sale. However, records show the Loft Board registered the unit and listed the prior occupant as the protected occupant before the sale took place. Second, tenant argues the sale is invalid because it makes no mention of Article 7C rights. Although the sale did not explicitly mention Article 7C rights, circumstances surrounding the sale show the intention to sell Article 7C rights. The 1995 sale took place after owner registered the unit and listed prior occupant as the protected occupant. Instead of moving forward with the coverage application, prior occupant agreed to withdraw his coverage claims with prejudice and move out in exchange for compensation. Third, tenant argues the sale is invalid because owner did not file the sale with the Loft Board within the time required by 29 RCNY Section 210B. But there is nothing in the Loft Board rules or Loft law that supports a finding that failure to timely file a sales record invalidates the sale. Staff recommends the board deny tenant's applications.
Thank you, Mr. Clark. Does anyone have any comments on this case? Mr. Delaney.
Yeah, I'm going to vote against this case, and I urge my colleagues to consider doing the same. This is an extremely unusual case in that the landlord registered the building with the express intent of contesting coverage. At the same time, there ended up being an agreement which led the tenant to withdraw his coverage request. And to my knowledge, this is not the garden variety. I've lived in this loft. I've been a protected occupant for 5 years, 10 years, 20 years, and I'm now selling my rights as a protected occupant, and I'm no longer a protected occupant. In this case, it's not clear to me that the individual, Mr. Lilly, who allegedly sold those rights, was in a position to do so. Recently, we've seen cases where we question whether a transaction between a protected occupant, who is clearly a protected occupant, and the landlord rises to the level of being a sale of rights. And reading carefully through the transcript at oath and the stipulation that only arrived at the Loft Board a decade or so later, I believe, there's nothing in there that convinces me that this was a sale of rights. I don't believe the tenant was in a position to make the sale at the time. I'm going to vote no. I urge people to join me.
Thank you, Mr. Delaney. Does anyone else have any comments on this case? With no other comments, then do we have a motion then to accept this case? Mr. Carver, is there a second? Mr. Schachter and Ms. Rivera, could you please close the order?
Mr. Carver?
Yes.
Mr. Barber?
Yes.
Mr. Rush?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
No.
Mr. Shackler?
Yes.
Chairperson Hudson?
Yes.
6 in favor, 1 against.
The next case on mass calendar is also going to be presented by Mr. Clark, but it is actually a protected occupancy and rent overcharge case. It is Thomas McKenna at 870 Broadway in Manhattan, and the docket number is P00016 and TA0210. Mr. Clark.
Tenant, occupant of the second floor unit, filed an application seeking protected occupant status and a rent dispute application. In determining protected occupancy, records show owner registered the building pursuant to MDL Section 281-4, and tenant's occupancy began on May 1st, 2010, well after the effective date of the law, which is July 27, 1987. Therefore, the relevant section of 29 RCNY Section 2-09 would be B3, which applies when a person took possession after the effective date of the relevant law. Staff recommends the board grant tenant's protected occupancy claim because he is a prime lessee with a lease that was currently in effect at the time the application was filed. To calculate a rent overcharge, the Loft Board compares the total amount of rent paid during the relevant period with the aggregate amount of the maximum permissible rent for the same period. There is no dispute tenant paid owner all of the rent required under the lease agreements. Based on the formula, for the 4-year period preceding the filing of the application, tenant was overcharged. Therefore, tenant recommends the board grant tenant's applications.
Thank you, Mr. Clark. Does anyone have any comments on this case? Is there a motion then to accept this case? Mr. Delaney, a second. Mr. Roche. Mr. Rivera, could you please call the vote?
Mr. Carver.
Yes.
Mr. Barber.
Yes.
Mr. Booth.
Yes.
Mr. Hernandez.
Yes.
Mr. Delaney.
Yes.
Mr. Shackler.
Yes.
Chairperson Hudson.
Yes.
7 in favor.
Thank you. The next case on the master calendar is Grigori Levitt, and that address is 103 North 10th Street in Brooklyn. Docket number TR1073, and Mr. Bobbitt will present.
Thank you. This coverage application is now before the Loft Board for the 4th time. Owner and tenant previously entered into 2 separate agreements in which tenant agreed to withdraw his Article 7C coverage claim with prejudice in exchange for the continued right to residentially occupy units in the building which did not have a residential certificate of occupancy. The Loft Board rejected both agreements as against public policy and remanded tenant's coverage claims to oath 3 separate times. At the scheduled trial, tenant defaulted and owner moved to dismiss tenant's coverage claims with prejudice. The Loft Board's rules state that where an applicant fails to appear at a hearing on due notice, which has not been marked final against the applicant, the Loft Board may dismiss the application without prejudice. However, where a notice of trial has not been marked final against the applicant, the Loft Board has considered other factors in determining whether to dismiss an application with prejudice. Here, tenant has invoked significant public resources, both at oath and at the Loft Board, in bringing his claims to trial. Tenant filed a coverage application and a reconsideration application, participated in multiple conferences at oath over a nearly 5-year period, executed 2 proposed agreements leading to 3 Loft Board orders, and most recently requested an adjournment of the trial date only to default on the adjourned date. Tenant filed for coverage in 2013, and there's still no progress as to tenant's coverage claim. Tenant has had nearly 5 years to adjudicate his coverage claims, and every single opportunity, tenant has chosen not to. Staff recommends that tenant's coverage claims be dismissed with prejudice.
Thank you, Mr. Bobbitt. Does anyone have any questions or comments on this case? There is no comments. Then can I have a motion then to accept this case? Mr. Carver, is there a second? Mr. Barrows? Ms.
Mr.
Rivera?
Carver.
Yes.
Mr. Barber.
Yes.
Mr. Roche.
Yes.
Mr. Hernandez.
Yes.
Mr. Delaney.
No.
Mr. Shackler.
Yes.
Chairperson Hudson.
Yes.
6 in favor, 1 against.
Thank you, Ms. Rivera. We come to the 2 removal cases, and they are 228 West Houston Street, Houston Street LLC, 228 West Houston Street in Manhattan, docket number LE 0679, and the final case is 2413 Third Property Owner LLC, and that address is 2413 3rd Avenue in the Bronx, LE 0688. Does anyone have any comments on these cases? There are no comments. Is there a motion to accept these cases? Mr. Carver? And second, I'm sorry. Mr. Barber. Ms. Ferrer.
Mr. Carver?
Yes.
Mr. Robert?
Yes.
Mr. Rose?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
Yes.
Mr. Chapman?
Yes.
Chairperson Henson?
Yes.
7 in favor.
Thank you, Mr. Rivera, and thank you, board members. We've come to a conclusion of February 15, 2018 Loft Board meeting, and our next public meeting will be here at 22 Reed Street, first floor, on March 15, 2018 at 2 p.m. Thank you very much, and board members, please remember to turn in your attendance sheets.